welcome to the second and final webinar in our two-part series. So our first webinar a couple of weeks ago focused on the top 5 most significant construction cases of 2025. And this webinar will discuss the top 5 cases which arise from adjudication decisions in the past year. So our discussion today will focus on adjudication practice and how this might affect your construction disputes coming up in 2026. We will highlight the main facts and legal points from each of the decisions and identify some key practical takeaways. In the time available, we will just provide an overview of some of the points which are the most relevant from these decisions to take forward. So this webinar is going to be recorded and will be available later on our YouTube channel. So if you would like to listen again or pass along to a colleague to catch up, please feel free to do that. The first webinar in the series on the top 5 construction cases is also already on our YouTube channel if anyone would like to catch up on that one as well. So before we begin, there's just a few housekeeping matters to start with. So just to minimise any background noise, I have placed you all on mute, but if you would like to ask any questions, please feel free to do so with the webinar Q&A function. To keep within our 30 minutes, we'll answer just as many questions as we can at the end of the presentation rather than as we go along. But if we don't get to your question in time, or if you are listening later to a recording of this webinar, we would be more than happy to address any questions by phone or by email. Our contact details are just on the next slide to let you do that. So just to introduce ourselves, I'm Kirsty Gray. I'm a senior solicitor in the Property and Infrastructure Disputes team at Shepherd and Wedderburn, specialising in construction and engineering disputes. I'm joined today by my colleague Alejandro Cohill, who's a solicitor in the Property and Infrastructure Disputes team as well. So our work focuses on construction disputes across a number of business sectors, and our team is experienced in traditional litigation, alternative dispute resolution, including adjudication, and dispute avoidance across the UK. Our team also regularly advises on construction contract issues and disputes across a range of projects and industries, including engineering, energy, transport, education, hospitality, leisure, and commercial real estate. As specialists, we have an up-to-date understanding of the legislative, court, and industrial context of disputes, but we also take that with a strong commercial focus. We advise our clients on various standard form contracts on a regular basis, and that variety of practice also means that our team has a good experience across a range of disputes. I'll pass across to my colleague Alejandro now, who's just going to run through the agenda for this morning.
Thank you very much for the introduction there, Kirsty. So in this webinar, we will focus on 5 adjudication decisions from 2025, which have important consequences for the construction industry. The cases that we will discuss today all have the potential to impact adjudication practice. So today we will discuss Clegg Food Projects Limited against Prestige Car Direct Properties Limited, Construction Muzzy Limited against Davis Construction Southeast Limited, RNJM Limited against Purpose Social Homes Limited, London Eco Homes Limited against Raise Now Ealing Limited, and finally VMA Services Limited against Project One London Limited. So just to give a sort of quick summary of each of the cases before we dive into them. The Clegg Foods case involved the court enforcing an adjudicator's decision to apply their own fair and reasonable rates. In Construction Muzzy and Davis Construction, it was confirmed that an adjudicator's decision in 2 separate but substantially similar adjudications were both held to be enforceable by the courts. RNJM Limited against Purpose Social Homes Limited focuses on whether a false statement made during the appointment of an adjudicator is able to invalidate that adjudicator's decision. An adjudicator's decision in London Eco Homes Limited against Raise Now Ealing Limited was enforced, confirming a settlement agreement was a variation to the original contract and not a standalone contract. And finally, VMA Services Limited and against Project One London Limited confirm that parties are entitled to raise a smash and grab defence to a true value adjudication. We have produced articles on the majority of these decisions that can be found on the Shepard & Wedderburn website, so please be sure to check those out. If you wish to read about the cases after the webinar, the articles can be accessed from the knowledge section of our website. But I'll pass you back to Kirsty for the first case that we'll be discussing today.
Thank you. So the first case this morning is Clegg Food Projects Limited against Prestige Car Direct Properties Limited. So here, an adjudicator's decision was referred to the Technology and Construction Court, and in this referral, the parties requested a summary judgment concerning the validity of the rates which had been applied by the adjudicator in reaching that decision. So, as background to the dispute, a JCT design and build contract was entered into by the parties in November 2022. Clegg Food Projects Limited, or Clegg, was the contractor, and Prestige Car Direct Properties Limited, or Prestige, was the employer. The valuation of an application for payment submitted by Clegg was the centre of the dispute. The dispute was not resolved between the parties themselves, so one of them had referred it to adjudication. The adjudicator was requested by both parties to determine that each of their own valuations was correct, or alternatively that a valuation of such other sum as the adjudicator may decide should be made. So the adjudicator's decision was that Prestige had undervalued the amount that was due to be paid to Clegg. Prestige was therefore ordered to pay Clegg a sum of around £540,000 plus VAT and interest. So the undervaluation had related to 8 relevant charges under the contract, and valuing 5 of them, the adjudicator had applied their own fair and reasonable rates. Prestige, the defendant who was ordered to pay, refused to pay the sum which was ordered by the adjudicator. Prestige refused to make that payment because they claimed that the decision was unenforceable, on the basis that, firstly, the decision was in breach of natural justice, and secondly, that sufficient reasons had not been given by the adjudicator in reaching their decision. Clegg, who didn't receive the payment, applied to court for summary judgment to enforce the adjudicator's decision and order Prestige to make the payment. The decision that the court took turned on the 2 principles which the court had to consider. Firstly, was there a breach of natural justice by failing to invite the parties to make submissions on the valuation? And 2, did the adjudicator fail to provide sufficient reasons for their decision? So, on the point concerning the breach of natural justice, Prestige's argument was that the adjudicator's failure to allow the parties to make submissions on the valuation award was a breach of natural justice. However, the court disagreed with Prestige's argument. The court noted that both parties had invited the adjudicator to either award the valuation set out in submissions or award such other sum as the adjudicator may decide. So the court did acknowledge that the adjudicator could not decide the rates without considering the parties' submissions, but the parties had sought a global valuation here. The adjudicator had not been tasked with deciding individual rates based on the parties' submissions. In addition, the court noted that the valuations which had been reached by the adjudicator were a halfway figure between the valuation submitted and valuations that Prestige put forward. The court was satisfied that the rates applied had been fair and reasonable, and the objection from Prestige that natural justice had been breached was unfounded. On the topic of sufficient reasons for the decision, the court was unsympathetic to Prestige's position that the adjudicator did not provide sufficient reasons for the decision. As we already discussed, the parties requested a global valuation. and expecting the adjudicator to determine the value of every individual line item was too granular and too unrealistic. The court accepted that fuller reasons could have been given in the adjudicator's decision, but that did not mean that fuller reasons were required or that the reasons that they gave were inadequate. And further to that, it was acknowledged by the court that even if the reasons were insufficient, Prestige had also not demonstrated that it had suffered a kind of substantial prejudice as a result of that. So, practical implications from this case that we can take forwards, this decision affirms that there is a high bar that needs to be met for the court to hold that an adjudication decision has breached the principles of natural justice, and for an appeal on that topic to be successful. So, although that's not necessarily a new development, the decision is a useful reminder and a useful highlight that the courts will give effect to the decision of an adjudicator if it's made within the discretion that the parties have afforded to them in the referral.
Thanks, Kirsty. So now moving on to our second case. So the headline takeaway from the Construction Muzzy Limited against Davis Construction Southeast adjudication is that two separate but substantially similar adjudications were both held to be enforceable in the courts. So to expand on this, two adjudication decisions made by the same adjudicator were challenged in the English courts on the grounds of natural justice and also jurisdiction. The court ultimately found both decisions to be enforceable and provided clarity that in order to render a decision enforceable on the grounds advanced, more than a fanciful prospect of success was required. So just turning to look at the background for both of these adjudications, a dispute arose relating to the quality of works out under two individual construction subcontracts. The employer was Davis Construction, who employed Construction Muzzy to provide groundwork and drainage work services. Now, Construction Muzzy was asked to stop the work at the site due to poor performance, which led to Construction Muzzy raising adjudication proceedings on both of the subcontracts. In both proceedings, the adjudicator favored Construction Muzzy, and as both disputes related to a failure to issue a pay less notice, the adjudicator required payments to be made by Davis Construction. However, these payments were not made to Construction Muzzy. So Davis Construction argued the adjudicator's decision was unenforceable as, firstly, undue weight was placed on an unsolicited surrejoinder by Construction Muzzy. Secondly, as the disputes were substantially the same, the adjudicator ought to have resigned from the later drainage works adjudication. And finally, the adjudicator taken a predetermined approach to the drainage works adjudication, breaching natural justice. So now, just to consider each of these arguments in turn, the court ruled the surrejoinder caused no unfairness and simply allowed Construction Muzzy to respond to the initial rejoinder. In addition, the surrejoinder had a very limited impact on the overall decision, so little or no weight was given to this argument by the court. Regarding the second point, as the adjudications essentially centered on disputes arising from two related contracts with individual facts, the adjudicator had jurisdiction. The court noted the adjudicator would only have to resign if the party was re-adjudicating a dispute that it had already lost. In regards to the third point, the court did not accept the predetermined argument. As Davis Construction failed to engage with the process, the adjudicator was left only with Construction Muzzy's evidence to consider, and this made it very difficult for the adjudicator to decide in any other way. And in terms of the practical implications of this case, there are two key takeaways, and the first one is that disputes arising under different contracts that are substantially similar can be referred to the same adjudicator, provided that they are separate adjudications. And the second key takeaway is that a high bar remains to have any adjudication decision rendered unenforceable and the courts continue to be supportive in giving effect to adjudication decisions. Then I'll pass you on to Kirsty for the third adjudication.
Thank you, Alejandro. So our third case is RNGM Limited against Purpose Social Homes Limited. This decision highlighted the importance of a referring party ensuring that they are making correct and accurate statements during the appointment process for an adjudicator. This case confirms that the courts consider that an adjudication decision can be rendered invalid and unenforceable if a false statement is made during the process of appointment. So, to go through the background of this case, RNGM Limited and Purpose Social Homes entered into a contract for the construction of an apartment block. During the course of the project, a number of disputes arose, which resulted in a series of 5 adjudications. The second, third, and fourth adjudications were each dealt with by the same adjudicator, and the adjudicator decided in favour of Purpose Social Homes in respect of all of those proceedings. The adjudicator directed RNGM to pay his fees. However, RNGM did not agree to pay them. Prior to the fifth adjudication, RNGM asked for a different adjudicator to be appointed, stating in the application form that the previous adjudicator had a conflict of interest due to an outstanding payment dispute. RICS, the nominating body, ultimately did appoint a different adjudicator. So the fifth adjudication commenced with the new adjudicator, and it was decided in RNGM's favour. Purpose Social Homes was ordered to pay RNGM a sum of around £130,000. Purpose Social Homes disputed RNGM's allegation that there had been a conflict of interest from the prior adjudicator, and they stated that there was no basis that was valid for RNGM to dispute payment of the adjudicator's fees. RNGM had, in fact, simply chosen not to pay them. So, as a result of this allegation of a false representation, which had the potential to cause unfair prejudice to Purpose Social Homes, the decision was referred to the Technology and Construction Court. On that decision, the court agreed that the misrepresentation had unfairly prejudiced Purpose Social Homes and dismissed the application for summary judgment against RNGM, or by RNGM. So this application was dismissed because the court had been satisfied that Purpose Social Homes had a realistic prospect of success in proving that the false statement by RNGM was made either deliberately or recklessly. Therefore, the appointment of the adjudicator and the adjudicator's subsequent decision was invalid. The court considered 3 factors in making this decision. So firstly, the information RNGM had provided in respect of the payment dispute, whether the statement that they made was actually false, and if the statement was false, was it deliberately or recklessly done so? When the court considered those factors, they noted that insufficient evidence had been given by RNGM to actually prove that the statement they made was truthful. And the court acknowledged it was telling that RNGM, who was making that allegation, was unable to provide evidence to support the fact that they said there was a payment dispute with the adjudicator. Looking to practical implications to take from this case, the decisions which we cover in this webinar tend to demonstrate that courts are quite hesitant to interfere with the decision of an adjudicator, but this decision does show that where a party has been unfairly prejudiced, the courts will look to intervene. The process to start an adjudication and appoint an adjudicator must be conducted in a robust and honest manner from the very start, otherwise enforcement of the decision reached can be at risk, and any subsequent decision as well can be at risk of challenge.
Thanks, Kirsty. So moving on now to consider the London Eco Homes Limited against Raise Now Ealing Limited case. The construction industry is experiencing quite an increase in the number of settlement agreements that are involving the carrying out of remedial works as part of the settlement. Now, this increase is largely explained by the reforms to the law following the Grenfell tragedy in 2017. Amongst other things, these reforms increase the likelihood of adjudications applying to disputes arising under these settlement agreements. London Eco Homes Limited against Raisenow Ealing Limited involved an adjudicator's decision that is in line with this trend. So, turning to look at the background for this one, London Eco Homes was contracted by Raisenow, the employer, under a JCT intermediate building contract. And throughout the life of the project, a number of disputes arose between the parties. The contract that governed the project allowed for the parties to refer any disputes to adjudication. But despite this, the parties entered into a written settlement agreement to end the outstanding disputes. And a key part of that settlement agreement was breached by Raisenow as it failed to pay the settlement sum. So London Eco Homes referred the failure to adjudication, and the adjudicator found against Raisenow, requiring a payment of £95,000 with interest plus the adjudicator's fees. Raisenow disputed the adjudicator's jurisdiction to make the ruling and refused to pay that sum. So London Eco Homes sought to enforce the adjudicator's decision and raised Part 7 proceedings. Raisenow's refusal was based on the argument that the settlement agreement, due to the presence of the entire agreement clause, was a standalone contract that intended to supersede and replace the underlying JCT contract. And if this were successful, it would mean the right to refer to adjudication in the original contract would not apply. London Homes, however, put forward an alternative interpretation that the settlement agreement was a variation to the original contract, meaning the adjudication provisions applied and that the adjudicator had jurisdiction. The court disagreed with Raisenow and enforced the adjudicator's decision. The reason the settlement agreement was a separate contract was that it did not require works and would fall under the definition of did not require works that would fall under the definition of construction operations. And as a settlement agreement was so closely tied to the original contract, it was ruled to be a variation. So the court's decision affirmed the adjudicator had jurisdiction, so Raisenow was required to pay the settlement sum. And in terms of practical implications, the main consequence of this decision is that parties should be clear about the application of provisions in the original contract when entering into a settlement agreement. This is increasingly important in relation to dispute provisions. Additionally, the statutory right to adjudicate may apply in a piecemeal fashion and not to the whole contract. And as these implications relate to contractual interpretation and drafting, if you require any assistance in relation to a settlement agreement, please let your usual Shepard & Wedderburn contact know, and we would be more than happy to assist.
Thanks, Alejandro. So just moving to our final case this morning. So this is VMA Services Limited against Project One Limited. The facts of this case are that in October of 2023, VMA had entered into a JCT design and build subcontract with Project One. The contract covered the design and installation of mechanism works, and it contained the typical construction contract interim payment provisions which you would expect to see under the Construction Act. In June 2024, a payment application was submitted by VMA. No payment notice or pay less notice was submitted by Project One. Due to that, the sum of just over £106,000 sought by VMA became a notified sum in accordance with the Construction Act. True value adjudication proceedings were then brought by Project One seeking payment. VMA refused payment, arguing that a true value adjudication could not proceed as the notified sum remained outstanding. The adjudicator decided that VMA's defence made was valid. The notified sum ought to be paid first. Project One refused to pay, so VMA ultimately applied to the court to enforce that decision. The court upheld the adjudication decision and confirmed that a smash and grab defence to a true value adjudication can be successful. So just turning to look at the decision in more detail, here the court affirmed a position that's set out in the Construction Act that a failure to issue a valid payment notice or a P-less notice means that the sum sought in a payment application automatically becomes payable and forms a notified sum. The court highlighted that the entitlement of a party to raise a true value adjudication requires no notified sum to be outstanding, and in the event that a notified sum is outstanding, it must be paid before proceeding further with adjudication. So the key sort of practical takeaway from this case is that it would be valid to raise a smash and grab defence to a true value adjudication. The smash and grab defence would halt the process of the true value adjudication, and this case confirms it's valid for an adjudicator to order payment of notified sums that fall due.
So we've reached the end of the presentation today, and it looks like we still have a few moments left to answer any questions that any of you may have. So if you've not already done so, please type your questions into the Q&A function now. Looks like we have a question from the Q&A function. So the question is, can you please explain the process of how you would actually go about challenging an adjudicator's decision? Yeah, good question, especially considering that the adjudications that we've discussed today all involved a party challenging an adjudicator's decision. Now, there are two primary methods to resist the enforcement of an adjudicator's decision. And this is by either proving that the adjudicator had no jurisdiction to make the decision, or that there was a material breach of the rules of natural justice. So to take both those points in turn. In terms of the jurisdiction challenge, it is important that the position in respective jurisdiction is reserved from the start. So typically, jurisdiction reservations are made at the point at which the notice of adjudication was served. So that's at the point at which it's made. And the party making the reservation should state that any further involvement with the adjudication is without prejudice to that jurisdiction objection. And just considering the sort of rules of natural justice, there's a very high bar to prove that an adjudicator breached the rules of natural justice, and successful challenges on this ground are very rare. Essentially, the party making the objection must prove that the adjudication process was not a fair hearing by an impartial tribune. So some examples of successful natural justice challenges include the failure to take account of a party's submissions, for example, and the failure to provide reasons for the adjudicator's decision. It's also worth clarifying, actually, that even if a party intends to refer the adjudicator's decision to the courts or to arbitration, the order must be complied with in the meantime.
Thank you, Ali. I think that's all we have time for today. So if anyone has any questions that we haven't answered, or if questions arise in the future, please do get in contact with a member of our team. Our contact details are just on the slide. I hope you all found the webinar engaging. The webinar has been recorded and it will be available on YouTube. So if you have any colleagues who haven't been able to join today, or if it would be useful for anyone, please do let them know. We'll circulate the details of the recording to you all after the webinar. So thank you all for attending today, and for the engagement with this webinar and with the webinar series as a whole. If you would like to provide us with any feedback, including topics that you would find useful for future webinars, you will receive a feedback survey as well. We also host webinar series throughout the year, and we'll be in touch with you for details of our next webinar series in due course. So just thank you again, and goodbye and have a good day.